great to have you with us. Presenters today are there on the screen, myself, Patricia and Mark. So really good to be with you this morning. What are we going to be doing as part of our immigration update? I'll come to that in a moment, but first a bit of housekeeping. There will be a recording of the webinar available, so if you want to share that with your team, get people to watch it and so forth, you can do. It will be available on our website at some point after the session, so it can be accessed there, and a copy of the slides will be sent out with the follow-up from the event as well, so you'll have all that. If you've got a question as we go through, it'd be great if you'd like to raise that, pop it in the Q&A box, the Q&A, not the chat, Q&A, and then we'll try and pick out some of those as we go. We've got lots of people on the webinar, so we may not be able to cover every single question, but if you put questions in there, we'll try and pick out the common themes, perhaps ones that are of most relevance, and pick those up towards the end if we have some time. We're aiming for about 45 minutes, so hopefully finish in good time before 11 o'clock. Great, so what are we going to be covering today? A bit of a news sort of roundup session, I think, today. So we're going to spend a little bit of time looking at some significant increases that have taken place on some immigration fees, and also thinking about some of the things that you might want to do practically to address some of that. I'll spend a bit of time looking at right to work issues. So there's some fairly big changes around legal working civil penalties and the financial sums that you can be fined if you get stuff wrong. So I'll look at that, some of the practical bits to think about around that. And also spend a little bit of time looking at the IDSP checks, which I'm sure, as many of you know, is a relatively new way of checking British and Irish passport holders via a third party that can run a check to help you with that process. I've had quite a lot of queries on it. It's definitely not as quite as straightforward as many people thought it might be. So I thought I'd run through that in a bit of detail and give you a few practical pointers on how to work those checks. We've then got a roundup of some other developments that Mark and Patricia will take us through, mix of things, all sorts of stuff going on. So a general roundup of things, particularly as they affect, obviously, sponsors and work-related visas. And then we'll finish up with a bit of a topical question looking at student right to work issues after they've completed their studies. Again, another topic that we've had coming up quite frequently recently. As I say, if you're just joining, do feel free to pop some questions in the Q&A feed. We'll try and pick out some of those towards the end and hopefully cover those off. Great. So before we kick off on the substance of those things, I just wanted to share a few bits and pieces on the latest immigration statistics and also some attitudes that have come out through surveys in terms of British attitudes to immigration. Quite interesting, and kind of shows the complexity, I think, of policy making at the moment. Just in terms of the latest statistics which came out in August, so taking us to the end of June 2023. Basic story is there's a massive increase in the number of visas being issued, which, as you know, many of us will know, is probably counter to what many people expected might be the outcome of Brexit. So you've got almost 3.3 million visas issued in that 12-month period to the end of June 2023. A chunk of that was Ukraine, just under 250,000, but a 45% increase in work visas, so 320,000 skilled worker visas, well, work visas, of which a good number was skilled worker. Huge increase in health and care visas. I know we've got lots of health and care colleagues on the call, plenty of those going on, and almost 500,000 study visas. That's obviously an area that the government has indicated it's minded to tackle. And interestingly, 7.4 million applications under the EU settlement scheme, so well in excess of the 3 or 4 million that many expected back in 2016, 2017. So a huge increase in the number of visas that are being issued. And interestingly, the benefits of immigration economically have been highlighted for a report that the Centre for Economic and Business Research did. So they've kind of looked at some of the statistics of this, and they've worked out that the UK economy net is £3.3 billion better off as a result of the immigration we've been happening than if there'd been none from 2022, and just under 1% of GDP is attributable, they say, to to the immigration, the net immigration. So, economically, the figures suggest that there's a big benefit. And yet, there's been quite an interesting report by the Migration Observatory around public attitudes to immigration. This might not be surprising, given some of the stuff that's out there, but just over half of people apparently think that immigration should go down, and 32% said it's a bad or a very bad thing, immigration. And opposition seems to have hardened and increased since 2022. There's a bit more of a preference for sort of skilled worker routes. Younger people and better educated people seem to have a slightly more positive attitude to immigration. But yeah, it's clearly quite a divisive issue given those statistics. It's a really interesting report. The Migration Advisory Committee on their website, linked to the University of Oxford if you'd like to look at that. And that's also consistent with a British Futures survey that came out, which tracks immigration attitudes. And again, essentially has registered a high level of dissatisfaction. And then you kind of flip that round, and the Royal Society has issued a report around borders of science, making the UK visa system work for short-term research mobility. So one of the main sectors trying to navigate the system. No great surprises with what they've come up with, but they've indicated that the costs, the processes are much more onerous than in many comparable countries. They say they're bureaucratic, arbitrary, take a long time. Many of us would sympathise with that. Refusal rates are high, a bit of a perceived bias to the global south, which I think also anecdotally is what many immigration practitioners would observe as well. And they say is really damaging research collaboration. So some researchers reporting they actively look to chair conferences outside of the UK because of some of the immigration issues that are there. And they've made a number of recommendations around transparency, processing times, improved communications with applicants, and also suggested a short-term mobility equivalent to the global talent visa for these kind of short-term type projects. So, I mean, where does all that leave us? I'm not trying to bombard with stats, but just to highlight some of the complexities for policymakers out there, which obviously feed through to all of us who are working in the sectors dealing with this, and many employers and businesses that are trying to navigate these rules. I think what we can say is we're still in a position where Brexit has definitely not resolved, whatever that would look like, this issue. We've still got obviously huge drivers for economic growth, of which clearly from the stats, it seems that immigration is a big lever, and yet the pressures on governments around public attitudes to that means that it's not being pulled in the way that it perhaps could be. We've got an election on the horizon as well, albeit at the moment, it doesn't seem in the sort of work visa sphere to be particularly topical. It's more around obviously the asylum, the boats, as the government calls it, and so forth. So certainly a really complicated picture, but interesting in terms of where attitudes are at and what the impact is on economic growth. That's enough of my waffling and pontificating on topics that are probably of limited relevance or interest possibly to some of you. Let's move on to some of the kind of nuts and bolts, a bit of an update. Firstly, immigration fees. Patricia, over to you.
Thanks, Alex. As you know, there's been significant Home Office fee increases from 4th of October. They affect various visa and nationality application. For example, most work and visit visa fees have increased by 15%. There is a 35% increase for student application from overseas, and 20% increases to wider entry clearance fees, citizenship and indefinite leave to remain application, and COS and CAS fees. COS fee has increased, for example, from 199 to 239. And there's also a larger increase for overseas non-settlement priority service, which is now 500. On the bright side, the immigration skill charge has not been increased, which is really good news, because unless you're exempt, medium, large sponsors are already paying a hefty $5,000 to sponsor a worker for 5 years, and they cannot pass it on to the worker through any means. The biggest increase, which has not come into force yet, will be the immigration health surcharge. For most applicants, it will increase from $624 to $135 per year of sponsorship, which is a 66% increase. It's a lot. There's currently no news from the Home Office as to when the plan increase will take effect, but it is expected either later this year or early next year. it goes therefore without saying that the sooner you can make an application, the better. You will save money, and you may also want to consider the length of your sponsorship to save cost in the long run. We're all, of course, unhappy about these increases. They've been criticized by many, including the British Academy, as the fees charged in the UK were already far higher than comparable European countries and the US. The British Academy expressed its concern regarding the potential impact it will have on early and mid-career researchers with young families who are now facing significant upfront cost. And I think that also applies to any migrant and their family coming or already in the UK. Some employers are already using clawback clauses in contract of employment where they offer to pay the visa and health surcharge cost, but insist on repayment in the if the employee leaves. So it's just like a payback clause you often find in a contract binding the employee for a certain period of time to compensate you as the employer for any investment in their training. This is worth considering given how much the fees amount to these days. So that's a brief summary of the increase in immigration fees. If you want the table of the fees and increases, do let me know, and it's also available online.
Brilliant. Thanks, Patricia. So we'll turn from that to a bit of a right to work update. So a few bits and pieces to let you know about here. The first is the increase in civil penalties that are due to kick in January 2024. So I think probably most of us know that if you negligently employ somebody that doesn't have the right to work, you're exposed to a civil penalty as a result, and you can get a defence to that penalty if you do the right to work checks prescribed in the employer guidance. Hence why getting those checks right is so important. So you get that defence if it turns out the person doesn't have the right to work and you're not exposed to these sorts of penalties. If you do get it wrong from next year, we haven't got the precise date yet, but it's January, it looks like, then those penalties are increasing really quite significantly. So the first breach, you're looking at an increase from £15,000 to £40,000 per employee, and then subsequent breaches 20k to 60k for each employee. So really quite significant financial penalties. And you might think, well, these are sorts of things for employers that just sort of flout the rules, don't care, ignore, don't do things properly. But put simply, they're basically applied strictly. The intention of the employer and the knowledge of the breach is not usually a relevant factor, and these issues often arise just from an oversight or administrative error on the part of an employer when onboarding somebody or doing repeat checks when somebody's getting an extended visa, or just a lack of awareness of the rules, because they are increasingly complicated. The days of having a list of documents you just checked and then the person can start work. You've now got all sorts of different ways that somebody can be checked, as we'll look at in a moment, and that apply in different circumstances. And it's not easy to navigate. I think the employer guidance is 60 odd pages, not all of it desperately clear either. So it is a tricky area. And of course, if you are in the territory where you've got some knowledge, or knowledge could be imputed because you've got reasonable grounds for believing somebody doesn't have the right to work, you're also exposed to potential criminal sanctions as well. So an unlimited fine, and if you're lucky, imprisonment for up to 5 years. So it is, it is a serious issue, and these are significant penalties that are going up from next year, and it's a real world risk. I mean, I've got clients that over the years, have made errors, things have come to light, and they have been issued with, significant penalties as a result. It is just what happens. It's not a sort of theoretical risk. So where does that take you to? I mean, a lot of this is going to be fairly standard stuff. But the first thing is you want to make sure that you have really robust systems for right to work checks. Make sure that they're being done at the right time, before start of employment in almost all cases. You've got the right people doing them. Do you want to have managers on the ground doing them, or do you want to make sure that people in HR and people in culture departments are there doing them because they know what they're doing? Making sure that copies are being taken properly. You've got full, clear copies that are annotated in the right way with dates where appropriate. all those sorts of things. You've got to make sure you've got robust systems. This is an increasingly important thing to get right. You often get errors, I think, on the repeat right to work checks. So dates aren't diarised properly. Issues fall between two people in holidays, whatever it is, when somebody's coming up to an expiry. Again, systems to make sure nothing falls between the gaps, that where pending applications are made, you're making use of the employer checking service to get a statutory defence to that civil penalty. All those sorts of things are really important. And I think, it's always good, isn't it, to do a spot check of employee files, do a bit of a mini audit. That's what the Home Office will do when they come in and do audits, not just of sponsored workers, but they will potentially want to look at all files, spot check from all files, because it's a sponsored duty to make sure that you are having robust systems to prevent illegal working. But always bearing in mind that the documents that you will have on file and the checks that you should have done will vary depending on when the employee started. So somebody that started back in 2002, 2003, a very different regime, for example, applied then compared with what's required now when somebody is joining. And I think training is always critical. Training for staff conducting checks, understanding the different methods, understanding what they have to do, understanding why it's important. Yeah, it's more important than ever, because if you have a systematic failure and a number of employees who have ended up not having the right to work, then you can potentially be exposed to a substantial six-figure penalty in no time at all. Just in terms of right to work checks, so a very quick reminder, you've now got these four ways, haven't you? You've got the old school manual check, so that might be for entry clearance, sort of vignettes, or possibly passports for British or Irish nationals where you're not using the IDSP service, but increasingly phased out. You've got the IDSP check, which we'll use at the moment, look at in a moment, using a third-party provider. You've got the online checking system. Increasingly, that's the system that the Home Office is trying to get everything migrated over to. So essentially, anybody with a biometric residence permit or card, frontier worker permit, anybody who's got digital status, like under the EU settlement scheme, that's used the app when doing their details when making their application. That's increasingly the portal via which these checks are done. And then the employer checking service, typically used to check whether somebody's got an in-time application and they've got carryover leave, but sometimes also part of the manual check system, depending on the documents that the employee has. Those in a nutshell are the four ways, and obviously each has different requirements and processes attached to it. We're not going to go through them all by any means, but I just wanted to touch on the IDSP checks, which I think are sometimes misunderstood by employers that are currently using them, or indeed by people who are thinking about making use of a third-party provider. It's not a way that you can just outsource right-to-work checks to a third party. That's not how it works. This is a system that essentially enables you to get a third party to use a digital check process for British and Irish citizens who hold a current valid passport. If it's expired, you can't use this system, but you can do a manual check on an expired passport for a British or Irish national. If somebody says, I don't want to be put through this system, I don't want my details going to this third-party checking provider, you can't insist on that, and a manual check would need to be conducted instead. I mean, what is the process in a nutshell? Taking the details here from the right to work guidance published by the Home Office, you've got to go and get a clear, legible copy of an IDVT, essentially a document provided by this independent service provider, which enables you to effectively then run the check by looking at the documents and comparing it to the individual presenting for work. So you have to look at the names on the check and the names of the documents that you've got that you're aware of. Are there any discrepancies? You've got to have a reasonable belief that the service providers complied with all of the relevant requirements in relation to their processes for checking. That's pretty difficult, I think, for employers to navigate. What I would say is that if you use one of the certified by the UK accreditation service providers, like, for example, Trust ID, then that will normally be sufficient, I think, to mean that that requirement is met, and be satisfied that the person presenting for work is the person who is contained in the details of this check, this IDVT, that the IDSP will provide to you. In practical terms, what does that mean? Once the IDSP has completed their checks, you then have to see the prospective employee. So you've effectively still got to go through almost a kind of a manual type check process using the information provided to you by the IDSP. The person can be in person or via a video call in terms of you checking them. And you've got to satisfy yourself that the photo, the biographic details, the date of birth, do they look like the right age? Are the names consistent? They're all consistent with the information on the check information, and follow up if there are differences there. So if there's a change in name, asking for a marriage certificate, deed poll stuff, all the sorts of things that you would have done when running kind of old school manual checks on passports, for example. And then you've got to retain a copy of the IDVT check on file as well in a form that can't be altered. So scanning it in, saving it on the systems that you've got on employee files, that's what you should do. So it's not as straightforward as you might be led to believe. And I think, where does that take you to? I think key thing is it's a great service. If you've got lots of turnover of staff, lots of people joining, big organization, there's lots of merit, I think, in using an IDSP. But you've got to make sure that your staff who are then conducting the checks, when the information comes back from that provider, they know what they're doing, they know what information they should get from the provider, they know how to conduct the check and retain the information on file, because you can't just outsource it to that third-party provider, which is, I think, what some employers thought the system may provide. And I think, flowcharts and processes, some basic guidance internally, particularly where you've got bigger HR teams, let's say, is really sensible. I'd also add to that although it's not a requirement, I do think it's sensible to annotate a copy of the check on the system with some wording, something like which I put on there. As I say, it's not specified as a requirement, but I think it's useful because it encourages the person who's doing the check to think, okay, am I doing what I need to do? I'm kind of sort of certifying something here on this document. Hopefully make sure they engage Brain properly, and you've got some record that it has been done properly, and hopefully who's done it as well. So I think that's a sensible step to take, notwithstanding it's not prescribed in the guidance as a requirement. Always interested to hear feedback on the system. So if you're one of our clients, you've got some feedback, do let me know. It's always helpful to have intel and see how it's going. I've generally heard positive things. I think using a certified provider brings lots of benefit, particularly, as I say, if you've got that high turnover of staff, lots of new joiners, but just make sure you've got your good processes internal to complete your side of those checks. So over to a bit of a roundup. Mark, over to you, I think.
Yes, thank you, Alex, and good morning, everyone. So we're just going to take you through a bit of a roundup in terms of the most recent changes we've seen to immigration policy and procedure over the past couple of months, beginning with probably the most significant change that we've seen, and this relates to new restrictions on switching capabilities for those who hold a student visa in the UK. So by way of some context and history here, it has been the case that individuals who hold a student visa have been able to apply from within the UK for a visa in a working visa category. So the most obvious example, would be the skilled worker visa. They've been able to do that from inside of the UK without restriction, really. And that's known as switching. They're moving from the student route to the skilled worker route. In practice, because there weren't really any restrictions on that, it did mean that it was technically possible for a student to enter the UK lawfully as a student, begin their course of study, and then immediately seek work, obtain work that meets the requirements for a skilled worker visa, obtain that sponsorship, and switch over to that sponsorship, which means that they weren't actually making proper use of their student visa, because obviously they'd switched into the skilled worker visa before ever completing their course. Now, rightly or wrongly, the Home Office saw this as an issue that needed to be solved. And the way that they've solved that is on the 17th of July this year, they announced and then immediately implemented new restrictions, the headline being essentially that student visa holders have to complete their course before they can switch into working visa categories. Okay. So that's the main takeaway. The mechanics of that are slightly more nuanced, and we've listed them on the slide for you here. So if a student visa holder now wants to switch into a working category, as I say, skilled worker being the obvious example, they can do so either if they've already completed the course for which their student visa was granted, or if they are about to complete the course, the sponsorship process for the skilled worker visa can actually commence, provided that on the certificate of sponsorship, the employer is putting a start date no earlier than the course completion date. So the point here is you can get the wheels in motion before the course is completed. You can assign the cause. The start date can be after the course completion date. In practice, of course, that means that the restriction still exists. The student isn't starting the work until after their course is completed, but you can get the ball rolling there. Or then finally, there is a bit of an exception available to PhD students. So the third sub-bullet point that we've listed on the slide there, if a PhD student is in the UK studying full-time towards their PhD and they have completed 24 months of that study, so they're 2 years into their PhD, they can actually switch. They don't need to complete the PhD in that scenario. So that's how it works. That's kind of the legal element of it. What does it actually mean for you? What does it mean when you're looking to employ and sponsor individuals who are currently here as students? I think there's probably two answers to that. The first is that hopefully it doesn't change too much, because in practice, I would say that most individuals who are switching from student to skilled worker visa category are or are about to have or will soon be completing their course. So it's not going to really have much of an impact, I don't think, on the type of individuals you are recruiting. But the second answer, and the more important answer, is that it does mean you need to be proactive in addressing these issues and building them into the recruitment timescale. So, for example, when I was speaking a moment about assigning a cause, but making sure that the start date is after the course completion date, you can only comply with that requirement if you know when the course completion date is. And that's the key point here. You need to be having that conversation with the student. You need to know from their perspective, when does the course end? And then not only do you need to know that, you need to get evidence of that. In terms of how you evidence that, the Home Office have updated their guidance on this. And so the starting point here is that you can obtain a copy of the CAS. And for those who are unaware with that particular terminology, so a CAS is to a student visa what a COS is to a skilled worker visa, by which I mean when the student visa is sponsored for their student visa, the institution sponsoring them will assign them a CAS. That will have the start and end date of their course. So if you obtain a copy of that from them, that's the starting point in terms of, well, you've got some evidence then of when the course has been completed, and the guidance says that you should be beginning with that. However, caution against relying on that solely. There will be circumstances whereby actually the course completion date is different to that as listed on the CAS. The most obvious being if an individual has completed their course, perhaps a few months earlier than anticipated. So it's important to be checking first with the individual, as I've already mentioned. Have that conversation with them. When do they say the course has been completed? Then ask them for some documentation that shows that. If the documentation is consistent with the information they've given you, that suggests there's no problem. If it's not, you then need to dig a little deeper and get some alternative evidence. Good examples would be a results transcript to show actually that the course has finished, that the results have been provided there. Or in the absence of anything else, ask the individual to get something in writing from the institution that's sponsoring them to actually say, yes, this is exactly when this individual's course completes. So as long as you've got some kind of evidence that shows when that completion date is, that's fine. And then a final point on this, there are obviously implications, I would say, as to how attractive the student route is to international students with these new restrictions. And those implications are only going to be compounded by more restrictions that are coming in on the 1st of January next year. So I'm not going to speak to this in depth, but the headline here is that basically from the 1st of January next year, most student visa holders won't be able to bring their dependents with them to the UK. So if we put all of that together, the student route is now more restrictive in terms of switching and will soon be more restrictive in terms of bringing family members over. So potentially we might see less people making use of the route. Obviously that remains to be seen, but a potential outcome to keep an eye on there. And then moving forward, we're just now going to do more of a quick fire round about some of the other more minor changes that we've seen here. So I will talk you through the top row here, and then I'm going to hand over to Patricia to talk you through the bottom row. So beginning with the box on the top left there, it is now the case as of this week that the SMS, the sponsor management system, has been updated to basically require national insurance numbers to be inserted in relation to any of your key personnel. And what we mean by key personnel are your level 1 users, your authorizing officer, and your key contact. Okay. This is something that the Home Office have been phasing in. So those who have submitted sponsor license applications more recently will note that actually it's been a requirement to include national insurance numbers for these individuals. It has always been an option to include them, but it is now required. What this means in practice, if you are making any changes to your level 1 users, your authorizing officer, your key contact, whether that's adding new ones, replacing individuals currently on the license, or even just updating the contact details of these individuals, the system will force you to insert a national insurance number when that change is made. Additionally, though, and more importantly, the Home Office messaging on this is that actually sponsors should be proactively dealing with this, and at the earliest available opportunity, and there's no requirement here, there's no deadline, but the earliest available opportunity, sponsors should be going into their license and saying, well, let's have a look at our authorizing officer, our key contact, and our level 1 users. Are their national insurance numbers currently listed? And if not, let's add them now. Okay. So from a housekeeping perspective, we would recommend doing that as soon as you are able to do so. And as I say, it may be the case that you're looking at your license, and actually because you included the information originally, even though you didn't have to, it's already there and you don't need to take any steps to update it. And then a couple of additional points from me on the shortage occupation list. So firstly, the shortage occupation list was expanded in August to include a few more roles. The expansion wasn't significant. They've added some construction-related roles, so bricklayers, roofers, for example. More significantly, though, at the beginning of the month, the Migration Advisory Committee published the review of the shortage occupation list. So Migration Advisory Committee consult and provide advice to the government on elements of immigration law. And we'd been expecting their review on the shortage occupation list from last August, actually, and it's been delayed and was just released at the beginning of October. The headline here is that this review and their recommendation is that the shortage occupation list should be abolished. Now, worth noting immediately, the government are not obliged to follow the recommendation here. So we don't think the shortage occupation list is going to be abolished, and certainly if it is, it's not going to be immediate. But definitely an interesting development in that the MAC are basically saying, actually, we don't think the shortage occupation list is fit for purpose. It's designed to fill gaps where there are labour shortages in the UK, but all it's actually doing is undercutting wages in those identified areas. And so what they're recommending is abolish the shortage occupation list and, in theory, replace it with specific, tailored visa routes that are geared towards those shortage areas. Now, as I say, the Home Office don't have to follow this. We don't know what's going to happen with this. So this is really just a wait and see. We wanted to put it on your radar. I think practically speaking, some of the recommendations simply don't work, and trying to get rid of the shortage occupation list as it currently exists would be a huge undertaking. So Nothing to note now, just be aware of this. And obviously, as changes happen, we would keep you updated during our future sessions in any event. So that's everything from me. I'll hand you to Patricia to deal with the bottom row there.
Thanks, Mark. So a couple of updates on the EU settlement scheme. The first one, it's about the 2 years extensions are automatically granted to anyone with pre-settled status who have not applied for settled status. And those individuals should be notified of the extension directly, and their digital status should be updated. So you as an employer, they should be able to evidence their right to work in the UK. So you can carry out your follow-up check. And at some point in 2024, those with pre-settled status should start to be automatically upgraded to settled status if automated checks of government records such as HMRC, DWP, passenger name record travel. So when you travel outside the UK, your absences indicate that they qualify. It will be interesting to see what the Home Office position will be in cases where an individual has broken their continuity of residence in the UK and they're therefore not eligible for settled status. And so they may need to regularize their status under another route or leave the UK. And as their employer, you may be approached for sponsorship or any other support. So this reinforced the importance of having a good HR system in place and carry out your follow-up check in terms of right to work check. The other change regarding the EU settlement scheme is the more restrictive position on late application. The obligation to demonstrate reasonable grounds and the scope has been narrowed for applying after the deadline, which was quite a while ago. It was the 30th of June 2021, is now an application validity requirement rather than an eligibility requirement. That makes a big difference. That means that some application will not proceed to full assessment, and if the grounds for making a late application is not accepted by the Home Office, the application will be rejected and will have no right of appeal or no right to administrative review. So if an employee has a EU settlement scheme application assessed as invalid, they will need to apply to regularize their status under another route or leave the UK. And depending on their circumstances, they may not have the right to work while their application is being considered. So again, follow-up check. Make sure you diarize when their pre-settled status is due to expire, or keep good communication with your employees. Make sure they feel supported, and so that you have a good picture of where you're going forward. And another change is finally on a visa route that I'm quite fond of, is the change to the youth mobility scheme. Changes coming into force as of the 31st of January next year. The upper age range for Australian and Canadian national will be extended from 30 to 35. This is already the case for New Zealanders. Australian and Canadian national will also be able to apply to stay for up to 3 years, as opposed to the usual 2 years. And this scheme will also be extended to Uruguay and Andorra nationals. And one last point on this scheme is that remember that youth mobility scheme visa holders can switch within country to the skilled worker visa route, for example. So I hope that was helpful, and I will now hand over to Alex to discuss a question that we are frequently asked.
Great, thanks, Patricia. Just unmuting myself. Yes, so this kind of builds to some extent on some of the points that Mark was making, and I can see there's a few questions also in the Q&A feed on this topic. So work that a student visa holder is permitted to do after their course has completed. It's always worth remembering that the work rights for a student depend on the course they're studying, potentially the duration of the course, when they applied for their student visa, and the type of HEI, higher education institution, that they are studying at. But in practice, it's not very often that many of those points turn out to be that relevant. So I'm going to focus on the scenario where you've done the right to work check. This is a student studying at a higher education institution that's got sort of full sponsorship status, if you put it simply. and they're permitted to do 20 hours per week during term time and unlimited and during holiday time. So what is the position there? Time spent after the completion of the course counts as vacation time. So the 20-hour per week cap on working hours doesn't apply after the course has been completed. So they can work full time once that has happened, but they can't work in a permanent full-time vacancy, save for a couple of exceptions that I'll come to in a moment. So where one of the exceptions that permits them to work in a permanent vacancy doesn't apply, you're looking at essentially making sure that they are only working on a sort of fixed term basis. So at the very least, you'd need to make sure that even though they can work full time, that any contract they have, arrangements relating to that, are linked to the expiry date of their visa. So, you know, a fixed term contract. I also think it is sensible for the work to sort of appear slightly more temporary in nature, if you like. There's always a bit of sort of grey area around what constitutes a permanent full-time vacancy, but I think the minimum is that it can't obviously be an open-ended permanent contract. There is an exception to that where somebody can work in a permanent vacancy, and that is where they've either got a pending skilled worker application made up to 3 months before the course completion date, as Mark was explaining earlier, or they successfully completed their course if they were on if they're applying for a graduate visa. So slight difference there depending on whether or not it's a skilled worker application or a graduate visa, which they are applying for. Obviously, this dovetails with the points that Mark was making earlier in relation to the points on switching as well. But you can see hopefully that there isn't a fundamental problem or clash there. It's a kind of a sequencing point. So practically, what are some of the points that come out of that? As Mark was mentioning earlier, certainly, you know, a sensible document and which institutions are very familiar with issuing, do it all the time, is a letter on, you know, letterhead confirming, well, what are the term time dates? We know what is the course completion date. That's something that all institutions that are sponsors of students will issue and a student can get hold of. So that will certainly be a key piece of information to understanding, well, firstly, vacation dates and when the course is completed. Secondly, it's particularly important to remember that what constitutes you know, vacation time does vary depending on the course that somebody is doing. I'm not going to go into this in great detail. It's not that relevant to after the course is completed, but certainly for other periods of vacation time, somebody doing, for example, a postgraduate research degree, like a PhD, let's say, they will nearly always be deemed to be in term time the whole time, apart from specified periods of holiday they're granted by their supervisor, usually 6 weeks per year. So you've got to make sure you always look at the type of student that's involved in the course that they're doing. That should be reflected in the letter, but don't just assume that the term time dates published on the university website are applicable to all students. It will depend on the course that they are doing. And obviously cross-checking those dates in the sort of ways that Mark mentions is sensible, and making sure that any letter that you get provided by the institution doesn't have to be direct to you, can be sort of an open-ended to whom it may concern kind of letter, that does cover the relevant year in question. If it doesn't, you need to get a fresh one to cover the particular year in question, and keep that obviously on file with the evidence you'd have to keep from the online right to work check on the Home Office system. So yeah, in a nutshell, yes, after course is completed, they can work full-time, not permanent, unless you're in one of those exceptions around pending skilled worker application or pending graduate visa application, and getting the evidence alongside the online right to work check that shows that their course has completed in order to qualify for that. Great. So probably time to try and pick up some questions. I'll just pick up a couple that I spotted, and I'm sure Mark and Patricia have picked up some as well. There was a question around sort of wanting to potentially refuse sponsorship for somebody. That is a question that we get asked quite a lot. It is a difficult area. If you've got a sponsor license and a role qualifies for sponsorship, and the person who is applying for a role is the best candidate for the role, then refusing to sponsor them when you could do so does take you into race discrimination territory. Put very simply, that's going to be certainly indirect race discrimination, and it's going to be very difficult to objectively justify that. You're not going to be able to justify that on cost and administration grounds. That's just not really how the law works in that area. So you always face a bit of a risk. If you've got a sponsor license, you can sponsor somebody for the best candidate, and you don't do so, you've got that risk exposure. That's not to say you may not reach a view on how to handle a situation, and commercial drivers may be in play, but that is the risk that you're exposed to. The second one I was going to cover is around ECS checks, which I picked up taking a long time. That is true, actually. I have seen a few that are taking sort of 2+ weeks at the moment. Remember that if you've done an ECS check and you're reasonably satisfied that the person's got a pending application, so they've given you some evidence they've got an application that they've made, you've lodged the ECS check within a sort of 28-day grace period that's provided for, then you should be okay pending the outcome of the ECS check. And practically, I don't think there's much else you can do but wait for that. Key thing is make sure that you have evidence that an in-time application, if it's an extension scenario, was lodged. You've got the proof of the application being lodged, etc., so that you've got that position there. Mark, Patricia, I'm not sure whether you had any other points that you wanted to pick up from questions.
Yeah, conscious of time, that there were a couple of points just worth clarifying. There was a question around the price increases. Just to confirm, when we're talking about price increases, the position is that the price will apply at the point of application. So if an increase takes place later, there's no need to then top up, as it were. If the application is made validly at the time, you pay the relevant price at that time. We also had a couple of questions which Alex and I have kind of touched on, but danced around the issue a little bit because it wasn't entirely relevant to what we were saying. Just to confirm, when we're talking about student visa working and the restrictions that they are subject to, it is, as Alex has said, 20 hours in most cases, 20 hours during term time, unlimited outside of term time. There is an exception in relation to work placements that form part of the course of study. So just be absolutely clear, if a work placement forms part of a course of study and that work placement is permissible and is taking place, that can be a full-time role. That doesn't have to be a 20-hour a week role. And then one other thing I just picked up, there are a few questions around evidence and a couple of references to Appendix D, which are some of the requirements that sponsors need to comply with in terms of record keeping duties. The main one I noted was in relation to what kind of documents need to be kept from right to work requirements. Obviously, this is quite a large topic, but for the purposes of what we've been discussing today, and just to clarify a couple of the questions that were asked, when you are conducting an online check, the check is on the share code in the online. There's no requirement to have a physical document. However, as a sponsor, specific circumstances might exist that mean that you do have to obtain and retain a relevant document. So a good example is you might need a copy of the passport if you're sponsoring an individual for their entry clearance application, because you're going to need evidence of when they entered the UK, so the stamp on their passport. So whilst it's not required from a right to work perspective, it is required from a sponsorship perspective. And that also goes to, there was one other question in relation to Appendix D, specifically around, well, we accept that course completion might mean that the individual can start before the results are known, for example. But what if our role and the sponsorship that we're providing is contingent on an individual holding a particular qualification? Well, in that case, you need to be ensuring that you are not providing that employment until that qualification has been obtained. So it might mean a further delay while you're waiting for confirmation of the qualification itself.
Great. Patricia, were there any that you picked up? There may not be, but if you have, then...
I just want to add, because I think I might have scared a few participants about my 60% increase. So I just want to add that is just in relation to the healthcare surcharge. And So like skilled worker, most applicants need to pay that. But if they're applying for indefinite leave to remain or under the health and care visa scheme, they would be exempt. But the 60% is in relation to the healthcare surcharge, and the fee increase is determined at the point of the application. And if it takes longer for the Home Office to process the application, or they come back to you because they have questions or they need further information, it will not cost you more. You have or the applicant, because the fees have already been paid and it's at the date of the application, and if it was prior to the increase on the 4th of October.
Brilliant, great. Well, I promise we'll be finished by about 1:45, so it just leaves me to say thank you very much for joining us. It's been great to be with you. Do contact any of us, or indeed your other main contact. If, for example, that's Tracy Yates or anybody else, do let us know. Always very happy to help. And otherwise, thanks for joining. The slides will be sent out with the follow-up. Recording will be available on our website if you'd like to look at it again or direct colleagues to that. Otherwise, thank you very much, and see you or speak to you soon.